Hello and welcome to my channel. I'm Dana Lynette and I'm so glad you are here. Today's video is going to be a little bit off the beaten path of what I usually do. I am going to talk to you about how I received a photo enforcement ticket from the city of Dayton, Ohio, and challenged it and I won. Stay tuned. Okay, so I've got some notes here to keep me on track so that I don't ramble. Here we go. All right, so I visited family. Let me just say I am from Dayton, Ohio, originally from Dayton, Ohio, but I live in Kentucky now, and I have since I graduated high school over 20 years ago. So it's rare that I go back to Dayton. Almost never do I go back to Dayton. I do have family in Cincinnati and Dayton. My mom lives in Cincinnati. My grandma, before she died, lived in Cincinnati. So I visit Cincinnati from time to time, but honestly not as often as I should. So I don't even go to Ohio that much. So here we go. So I was visiting family and it was all good. Had a good family trip and came back to Kentucky. And about a month after this visit, I received in the mail a traffic citation from the city of Dayton, trying to charge me $85, saying I was speeding 12 miles over the speed limit on Hillcrest. This was, well, the citation had a copy of my car, the back of my car with my Kentucky license plate on Hillcrest, and which I was on Hillcrest that day, clearly the photo. So I got this citation and yeah, it's for $85. And so I had to think, do I want to pay $85? Which is what a vast majority of people do. People don't have time for drama, okay? And so in order to minimize the drama in people's lives, people often take the path of least resistance. If you know me, you know that that is not always the case. In fact, it is rare form if I take the path of least resistance in cases of a matter of principle. And I decided, you know, I did a little bit of research on these photo enforcement tickets. You know, where I live in Kentucky, we don't have photo enforcement tickets. So, you know, this was a surprise to me. And so when I got this, I had to decide, are you gonna just pay it, path of least resistance, and be done with it? Or are you gonna fight it? Now, I am an attorney, but you know, I don't be trying to go to court just because I'm an attorney. In my experience as an attorney, I have largely worked for the government and for nonprofits. And so in my experience, I don't end up in the courtroom a lot. Honestly, I feel like a bit of a novice in the courtroom because I don't fancy myself a litigator. But it didn't matter if I was a lawyer or not. You know, to me, if I feel like there's a need to take a stand, I will take a stand. And in this case, I thought, you know, I don't think it's going to be beneficial or helpful if I take the path of least resistance. So I'm going to fight it. Now, is that to say, well, Dana, were you even speeding? I don't know. They sent this ticket to me a month after I was in Ohio. Like, I had so much going on. This was very shortly after my grandmother passed away. I could not remember what speed I was driving on Hillcrest a month ago. Moving on. So, I scheduled a hearing. The hearing was at 1:15. I did not get out of court until about 4:30. When I tell you that I showed up to fight, and when I tell you they was ready to fight right back with me. Like, nobody cared that this was a traffic citation. Like, everybody there was there to fight to the end. They were giving nothing, and I was taking none of their anything. My experience by and large in this court proceeding in Dayton was largely positive. And so usually I'll praise before I push, but in this case, I'm gonna push and tell you the things that I observed and that I felt kind of had negative feelings about. And then I will talk about the positives. So I think there are two things that I wrote down as pushes. So for one, there was no actual prosecutor in the courtroom prosecuting this case. In the city of Dayton, they swear in law students who have not finished law school yet. Like I said, they're law students, to act as the prosecutors in in these cases. Now, I don't know if this is the only kind of case that Dayton does that, or if they have these students representing the prosecutor's office in other areas. I think that's a mistake. I was really surprised by it. And even though it's just traffic and they consider it a civil administrative matter, I think it's a very bad idea to have students serve that role in the absence of a prosecutor. I think it's one thing to have students in the courtroom when they're under the actual supervision of a prosecutor, but when they're in the courtroom representing the state, or in this case, the city, and that's it, that's a very bad idea. And so what I observed, when I walked in, I don't know that anybody knew I was a lawyer. There were probably 13 cases on the docket. I mean, it wasn't a lot. So when I walked in, there were two young ladies who were rising 3L. So they had finished, this is the summer, they had finished their second year of law school and they had 1 year remaining. One of the reasons that I think that was a bad idea, this whole notion of having students act as a prosecutor is a bad idea, is you're really not trained fully in the law. And if you're not trained fully in the law and you haven't passed the bar exam and you're not a licensed attorney, you should under no circumstances be unleashed, unsupervised to represent a governmental prosecuting entity. That's just a bad idea. You're not ready, you're not prepared. And I have specific examples in this case. And so when they opened the door is a little bit, let's see, court was to start at 1:15. They probably opened the doors to the courtroom at 1 o'clock. So as we went in, the girls proceeded to sort of work the room, and they're approaching each, well, they made an announcement and then they started approaching each person about their case individually, which I thought was a little bizarre. So their announcement was something to the effect of telling people this is not a criminal procedure, it's civil, sort of administrative in nature. If you got this kind of ticket in the school zone, there'll be a $40 enhancement, if you lose today, blah, blah, blah. And so, these 13 cases were people who decided we weren't just going to pay the ticket, we wanted to challenge it. And so as I listened to those girls work the room, as an attorney, you have to be careful when you're dealing with an opposing party. These people didn't have lawyers, obviously, so if an opposing party has a lawyer, you don't deal with that party, you deal with their lawyer only. It's as an ethical matter. But these were unrepresented persons who were going to represent themselves pro se. And so as they would sit down and talk with each person and I could hear them, it's almost like they were trying to persuade that individual as to, well, you haven't, if you can still choose to just pay the ticket now if you want, but if you proceed, there's a fine line, or there can be a fine line between giving information and cajoling. And as I listened to them kind of work the room and go around to each person, some of the conversations be very extended, and the nature of what was said, I was just like, well, that's not advisable. It's really questionable what is being said to these people, because some of the people very clearly communicated, I want to fight this. I'm not interested in anything other than, challenging this, but there were still efforts to kind of persuade. And so I think that that's not advisable. Any legal professional meaning licensed attorney would understand, the implications of what I'm saying. But as law students, I don't think they really grasped, well, obviously if they thought anything was wrong with what they were saying or could be perceived as being wrong with what they were doing, they wouldn't have been doing it. They should have just walked themselves in and sat down and let the judge, generally judges address the court and admonish people of their rights and what's going to happen that day and blah, blah. But these girls literally worked the room, went around to each person, had conversations, some lengthier than others. And not, in my opinion, there was some persuasiveness going on that shouldn't have been. So that's one reason I think there shouldn't be students in these situations unless they're supervised. And I mean actually supervised. The real prosecutors never stepped foot. The prosecutor that I have been communicating with, as far as my discovery request, I never laid eyes on him. He never stepped in. No real prosecutor ever stepped in the room. It was a magistrate, the lady who was like a bailiff, like a / clerk, eventually a sheriff deputy sat in the back, I guess for security purposes, maybe entertainment, and the girls and all of us. Oh, let me just throw this out there. So another example of why, law students aren't quite ready to be unsupervised as the prosecutor representing the prosecutor's office. I remember at one point I was probably kind of annoyed, trying not to show it, trying not to be a jerk in any way. I'm just literally defending myself in sincerity. But I think I was getting annoyed at some point, and I made an objection that normally I wouldn't have made, but I was kind of testing my theory to see, maybe I'm being overly critical. Maybe it's fine for law students. And so they were trying to admit evidence, and it was a document from the cops' office. And I objected on grounds of hearsay. I said that's an out-of-court statement, offered to prove the truth of the matter asserted, and therefore it's hearsay, so I object. And so the magistrate, I really respected this man during this proceeding, and I'll talk a little bit more about him in a minute. But the magistrate, I could tell he wanted to say something, but he paused and he looked at the prosecutor student and asked her, did she have a response? And she was really struggling. Like, it's a business record. She did not know to say that it's a business record, and under the business records exception, it's admissible. But I mean, that's basic for someone who has finished law school. She may not have even had evidence yet. And the law of hearsay is can be a lot of information and confusing. And if you're not experienced in it, you can just kind of get lost in what is what. And so, if you have an experienced attorney or at least supervising them, then something that base would not have happened. But she was rambling on when all she had to do was say business records exception. That never came out of her mouth. She was just going on and on. And that's an example. Disclaimer. This video, I am a licensed attorney. I'm not your attorney. And so this video is intended for information, education, and entertainment. This is not intended in any way as legal advice. Legal cases are very fact dependent, and you have to apply the law to the facts in every case. And so the facts of my case are going to be different from anyone who lives in Ohio. But for most of you viewing this, and probably all of you viewing this, there are, facts that are different. And so you can't rely on what I did, take notes on what I did, and then try and go and apply that as practice for your case. That's not advisable. You either are a legal professional, do your own legal research, or you should hire a professional. Or if you say, well, I'm not going to hire a professional, I'm going to represent myself, you have to do your own research and try the best that you can. You cannot rely on anything that I say in this video. Again, this is for entertainment and information and education about my experiences personally. It is not legal advice. Moving on. All right, so the things that I would praise, so the magistrate, and I mentioned his name only because I don't have negative things to say about him. If I had a ton of negative things to say, maybe I wouldn't say his name, maybe. But it was Magistrate Brandon McLean. And so I felt that, I didn't agree with every ruling that Mr. McLean made, but I felt that he was fair. Okay, now let's get down to the nitty gritty. Court resumes. Everyone's case was called before mine, and finally I was called. Miss Simmons. Yes, Your Honor. Please approach. Okay. So before the hearing, really commenced, I let the judge know that I had a motion in limine. I actually had two. I made two motions in limine. The first one was on the grounds of personal jurisdiction. Now, if you're a lawyer, you know exactly what I'm talking about. If you're not a lawyer, I'll take a minute to explain. A court has to have jurisdiction, meaning authority over the person or persons, the subject matter involved, and in the region. And if all those things apply, a judge has jurisdiction, they have authority, they can proceed. If a judge does not have jurisdiction, these are very generic statements, very generic general statements, then, then jurisdiction can and should be challenged. And so I did. The idea of personal jurisdiction is, does the court have jurisdiction over the person? In this particular case, did the courts of Ohio have jurisdiction over me? Well, in order for the court to have jurisdiction, they had to have a long arm statute authorizing this sort of jurisdiction. Remember, the city of Dayton sent in the mail a citation from Ohio to Kentucky to haul me before or bring me under the authority of the courts of Ohio. I'm not a resident of Ohio, I'm a resident of Kentucky, you know? And so every state has a long arm statute that says under general circumstances or under specific circumstances, anyone who enters this this jurisdiction, Ohio, has to submit themselves to the authority of the courts of this particular state, either generally or under certain circumstances. And that's going to be either a general long arm statute or a specific long arm statute. And so I just let the court know Ohio has a long arm statute, and I read out the statute. And as you know, I don't fall under the enumerated items in this statute. I was here to visit family, not to do business. I didn't engage in tortious activity. I didn't hurt or harm anyone. There's no contract involved. I was simply visiting family. Therefore, the court doesn't have jurisdiction over me per the long arm statute. The judge jokingly stated, or the magistrate, that, you know, this takes him back to law school, which it is one of the very base things of law school. And the girl, she may have made a minimum contact objection, I don't remember, but he could see that she was struggling. And so the magistrate allowed a 20-minute I think it was a 20-minute recess, so that she could, I guess, go back to the prosecutor's office and get her stuff together. But I think probably he also, I've been out of law school 10 years. He looked like he's probably a little older than me, so he probably been out, and I was a non-traditional, so he probably been out of law school quite a while ago. And as a magistrate, you don't deal with personal jurisdiction a lot. So he probably had that recess so he could go do his own little research and make sure he was remembering correctly, but I don't know. So after 20 minutes, she said whatever she said about minimum contacts, and he sustained. You know, for those legal scholars out there, as you are preparing maybe for similar cases, be mindful. You know, it's not enough that the state has, in my estimation, it's not enough that the state has a long arm statute. There are different kinds of long arm statutes. You're either going to have a general long arm statute that provides, you know, a person who generally has minimum contacts with the state, it's going to be a one-liner, falls under the long arm jurisdiction of the court, or the state is going to have a specific long arm statute like Ohio does. Ohio's long arm statute enumerates the conditions or the factors that will constitute the long arm jurisdiction or the court's ability to exercise jurisdiction over an outsider. And so it's not general. And so like I said, as I read through the enumerated factors in their long-arm statute, none of them apply to a visit to a family member, as mine was. And really and truly, I think that the court should have should have dismissed the case based on personal jurisdiction, because Ohio's long-arm statute is not general in nature, it is specific in nature. And so, but he didn't. And so we proceeded. I was prepared to proceed. So first motion in limine was a personal jurisdiction objection or motion to dismiss. My second motion in limine was also a motion to dismiss, and that was for failure of the prosecutor to produce discovery. So I submitted a discovery request by email to the prosecutor in June, and this hearing was July. And here's what I asked for. And this is just, I did enough research. For those of you who are thinking, why is she doing the most for a traffic ticket? It's a matter of principle. As long as the government sets up a system where they just can haul people into court by questionable means, like a lot of these photo enforcement and other traffic grabs for cash, for traffic citations, some traffic citations, and people don't challenge when they're off, then it will continue to promote that sort of behavior, and the government will never be checked. But if people say, well, you know, in this situation, no, the government is not right to force cash out of me this is wrong, it might be inconvenient to challenge it, but in the long run, or the long haul, it is worth it, the value of it. You get court cases that way that overturn things, that establish standards for the government to act, instead of the government just throwing up something they want to do and saying, we're the government, we're going to do it. So I challenged it, even though I'm not a resident of Ohio. All right, and so these are the things that I asked for in my discovery request. The discovery request. The radar operator's manual of radar device used to clock my speed. They did not provide that. I asked for the radar factory certificate of calibration. I did get that. I asked for the tuning fork certificate of calibration. I believe I got that. I asked for radar calibration records, not provided. I asked for tuning fork calibration records, not provided. I asked for event logs and officer notes, not provided. I asked for radar maintenance records, including repair orders, installation date, and vehicle, assuming it was mounted on the vehicle, speedometer synchronization, radar dash cam interface, if it was mounted, the purchase order of the specific radar and equipment used. And, you know, some of those things were just technical in nature, because a radar ticket is very technical and you have to be able to make technical challenges. And so you have to ask for these things in order to understand what you're talking about and understand, you know, how to challenge these kinds of tickets. The equipment is not 100% fail-proof. And so if you have all of this information and you analyze it, you might be able to show, you know, due to, you know, the heater was going and the whatever else was going, and this particular devices, radar or LiDAR device provides that, you know, these sort of radio waves or whatever can interfere with, you know, you can make a case if you apply yourself. But you have to have the discovery provided, and the prosecutor provided me 1 or 2 items out of this long list of things. So in my limited experience and observation, courts, that's courts, the judges and prosecutors can, I'm not saying they do in every case, but they can get lazy because they're so used to just processing masses of people through this system. And you know, 95% of the cases end in a particular way, and so they treat them all, you know, like this herd. And in my case, and even I've got a case, I'm challenging a traffic citation in Kentucky. The prosecutors did the same thing. They provided me what they wanted to provide me, which is the same thing they do in every case, without regard to my actual discovery request. And that's being lazy. And in doing so, you don't provide discovery, bro, you don't win. So the magistrate in this case ruled on my second motion to dismiss in limine. He said that he almost never does this, but in this particular case, oh, you know what, I should back up. He did say, you know, Ms. Simmons, did you file your discovery request in the case? Because he hadn't seen it, and he's just kind of trying to figure out what discovery request, what you talking about. And as a lawyer, you know, I probably should have gone to their, assuming the court even has the rules posted online, I don't know, but I should have checked to see. I hadn't filed my discovery request in the case. I sent it to the prosecutor and he acknowledged it. But in my email to the prosecutor, I told him, I am not certain whether I need to file my discovery request in the case. Please advise. He responded and said, Ms. Simmons, your discovery request is received. I'll get, you know, discovery to you as soon as possible. And that was it, like a little one-liner. That was it. He never replied to my comment about, you know, please advise whether I need to file this in the... Now, those of you who are attorneys and you're like, nah, that wasn't his response. You're right. But nonetheless, you know, so I had told the judge, I said, well, you know, I didn't file my discovery request. He said, well, that's required. And I said, well, I didn't, but, you know, I emailed the prosecutor and told him I wasn't certain whether that was required or not, but I emailed it to him and he responded. And he did not answer my question about filing it in the case. So based on that, you know, the judge understood, and he asked to see the emails, and so the girl went and got the emails, and he saw that, and he saw my discovery request, and he read it into record. So as to my motion to dismiss, the magistrate said, you know, he provided one thing. I don't even think it was two. I think he provided I don't even think it was something I asked for. I think he provided the paper that they provided in every case, a paper showing what the speed was clocked at, but like not the manual, not anything else. And so the judge said, I'm not going to dismiss the case, but I am going to limit the prosecution from entering into evidence, you know, their evidence pertaining to this technical matter of, you know, the LiDAR equipment. Honestly, I don't even recall if he limited in part or if he limited it entirely, but it was enough. I mean, to me at that point, that was the coup de grace. The case is over. You know, in Ohio, when you have in Dayton, Ohio, when you have this photo enforcement, you don't have to have a cop present. And so if you have a cop present, that's one thing because you have an officer's testimony. But if the judge doesn't allow, you know, the calibration or the technical LiDAR stuff that you're trying to admit into evidence, then what do you have? You have nothing. You have no witness, you have no case. And so really at that point, the case was over, but we proceeded, and I'll proceed here. So that was really a big ruling in my favor. And that should be the case anytime a prosecutor is lazy and will not provide discovery. Yeah, because I think in his response to me when he provided a copy of the citation and a copy of this document that, you know, listed the calibration testing or something like that of the equipment, he said, you know, all the other things that you asked for really aren't pertinent to this case, or like something he had no business saying. And so the judge saw that, and so he made this ruling. And so they couldn't enter that into evidence. There was no cop on the scene. And so, like I said, case over at that point. But in case I was wrong about that, we continued. Now, I want to get into the applicable law. And again, I'm not your lawyer, and this is not legal advice. So I looked at our Ohio law, RC, I guess that's Ohio Revised Code 4511.093, specifically subsection B1. Now, this statute, I thought I hit the jackpot. When I saw this. Provides that there must be an officer present when this photo enforcement equipment is being used. Now, that is a statute passed by the legislature. Excuse me. The problem is that that particular statute has been ruled unconstitutional. And apparently, the Constitution of Ohio has been amended, and there's what they call the Home Rule Amendment. And the Home Rule Amendment gives local municipalities, such as the city of Dayton, so much authority with respect to local laws, such as their traffic laws, and such as the use of photo enforcement equipment. And the city of Dayton provides that officers don't have to be present. So this matter has been litigated. I'm so glad that I went to Westlaw, because this is a traffic citation. If I had just said, well, this is a traffic citation, no big deal, I'm just gonna look up the statute and not even use Westlaw or LexisNexis or whatever to key cite or shepherdize, then I would have been looking real silly in court. But I'm glad I did my little research, and I saw that that particular law, while still on the books, had been ruled unconstitutional due to the Home Rule Amendment, and the city of Dayton had the right to have their own rules, and their rules don't provide that an officer has to be there, so the legislature or the state can't require that for them. That's my limited understanding of it. You do your own research. Even though this particular statute had been ruled unconstitutional, the legislature revisited the statute, and in doing so, they reenacted it precisely the same way without change to that requirement. And so I didn't do much research beyond that. I don't think there have been anything major happen. No, there hadn't. It's still on the books, despite the courts having found it unconstitutional due to the Home Rule Amendment. So it's still on the books. Do with that what you will. Do your own research. So so there's that. Let me read you the other cases that I pulled. I'm just going to give you the citations of these cases you can look at. This is the case of City of Dayton, Ohio versus State of Ohio. This is a 2020 case, 2020 WL, this is the Westlaw number, 2020 WL 138-23100. 2020 WL 138-23100. But I key cited, and this case has some strong negative treatment from the 2021 case of Dayton v. State of Ohio. All right, I'm not going to summarize these cases in any way. I'm just going to tell you these are cases that I read in preparation. Dayton v. State, this is a 2021 case. The citation is 170 Northeast 3rd 502. That is Dayton v. State 170 NE 3D 502. That's a 2021 case. And that has severe negative treatment. It was vacated and remanded by Dayton v. State of Ohio, the 2022 case, which do I have that here? Dayton v. State of Ohio, citation 167, Ohio, ST 3rd 565. That's 2022 case. And so that's some of the case law that I looked at. Case law was not extremely helpful to me, only to prevent me from walking into court looking like an idiot, talking about no officer was present, and the statute requires an officer be present, therefore case dismissed. Now, no, even though that's on the books, it was ruled unconstitutional by the states, and so unless something happened with the Home Rule Amendment, they kept it on the books, but it's still unconstitutional as far as I know. Like I said, I didn't thoroughly research that. So that's some of the case law that I looked into. We fought like cats and dogs. Like I said, you would not think that this was a traffic citation. Like, when I tell you they fought me, and when I tell you I fought back, and when I tell you they were thrown off, because who does that? Like, never have they experienced anybody in the courtroom, not even the magistrate probably, and they may not, after this case, experience somebody fight so hard against a traffic citation. That's just $85. But listen, like I said, it was a matter of principle. Anyway, so to close this video and sum it all up, they had the officer who reviews the photo tickets. She reviews the photo footage from those tickets. They had her come in and testify. Officer Thomas. I liked her because that lady just came to do her job. She had no agenda. She was not trying to make sure anybody did or didn't win. She was just there to answer the questions that were asked to her, and she was a straight shooter. So they asked her questions. Their evidence was inadmissible in terms of this photo, LiDAR, radar, whatever. It was inadmissible because their failure to comply with discovery. I made a couple of, and then of course I testified on my own behalf. I did counter-examine Officer Thomas, and that was it. As we were closing, just before we closed, I made two closing, was it two? I made a couple of closing, and it was, so when you get these citations in the mail, they have on here what they call their certificate, and it's where the officer makes the statement and signs it, swearing to the veracity of, the contents of this citation. I'm gonna read this to you. It says, based on my review and inspection of the recorded images, I state that the motor vehicle was involved in the traffic law violation indicated on this notice, and the recorded images are prima facie evidence of the traffic law violation. This notice was electronically signed and held pursuant to DMCR 510. I declare, under penalty of perjury, under the laws of the state of Ohio, that the foregoing is true and correct. Dion K. Thomas and her badge number. So my objection in closing was that this little blurb about the recorded images being prima facie evidence of the traffic law violation. My objection was under the Constitution of the state of Ohio. There is enshrined a separation of powers doctrine, and that the sufficiency of evidence does not lie with the executive branch. Rather, the sufficiency of the evidence, i.e., whether evidence can constitute prima facie evidence or not, lies in the purview of the courts. And therefore, that little statement is unconstitutional. He didn't make a ruling on that. This literally was like after closing statements. He's like, closing out, and I said, I have a final objection. I don't remember all the other details. I don't know that they're necessary. This video is really long. But that is how I challenged and won my photo enforcement case. I really thought I would win it on grounds of personal jurisdiction. I still think I should have, but I didn't. But when that prosecutor was lazy and failed to comply, then the judge made a fair ruling that, the evidence on this matter of, the LiDAR, whatever, can't be admitted, because how can she challenge that if you don't provide the discovery? That was a very fair ruling, and for them, it was detrimental. It was the coup de grace in this case. So thank you for watching this video. If you have questions, you can put them in the comment section. I don't know that I can answer them as I'm not giving legal advice, but if there's a question I can't answer, then I will. But again, I felt like the magistrate in this case was very fair. I'm not saying that the law student did a bad job. I'm not criticizing her. I'm saying that the city of Dayton, this is a criticism of the city of Dayton to put law students in that role when they're not directly supervised. There should be an actual prosecutor present during these proceedings. So thank you for watching and have a good day.
I should have mentioned that the order was sent to me in the mail as the magistrate took the case under advisement and mailed an order. Thank you.